Hello guys, welcome to LawPutra YouTube channel, and our today's topic is sources of jurisprudence. When we use the word jurisprudence, the word is made up of two Latin terms. One is juris and another is prudentia. So as I have written the word juris and prudence, it is made up of these two words. Juris means legal and prudentia means skill or knowledge. So the word jurisprudence connotes the meaning as basic knowledge of law. When we use the word law, what comes to our mind? The various definitions given by the various jurists we can find in many number of books. But the simplest definition of law we can make is this. Law is protection. Protection of right of you and protection from wrong to you. So this is the simplest definition of law. Law is the protection of right and protection from wrong. Now, when we consider law, law is meant for people. Law is meant for protection of the subjects. Law is meant to be above all. So no one can be above the law. And then we need to consider what are the sources of law. When we consider the sources of law, there are two basic sources of law. One is the formal source, another is the material source. When we consider the formal source, as already mentioned, it is meant for people, and people, they are regulated or they are governed by the state. So first formal source of law is will of the state, and second formal source will be will of the people. What people want, what problem people are facing, what impediments they are falling down in front of people. So that is the will of the people. When we consider the material sources of law, what comes to our mind is the legal sources and historical sources. Now historical sources that we need to consider, but the legal sources we can see the first and foremost is the customary law. What is being observed as a customs among the people, that is more important. Then second source of material legal source will be the case law, that is the precedents. What the courts have given decision in their various litigations that are coming in front of them, that is also important. So that is the case law. And third legal source shall be the statute law by the legislation. What the legislatures are enacting for the welfare of the people, or for mean for the people, for governing the people, for regulating the people, so on and so forth. We also need to consider as to what are the essentials of valid custom. So let us see what is the will of the state. Now, when we consider the state, we know what the state means. It means the government, it means the governing body, which aims at the governance of the people, governance of the subjects of the nation. And will of the state, we need to know what is the state. It is the primary and trusted authority for authenticated laws and verified laws. So whatever law is passed by the government, or whatever law is as per the will of the state, that should be considered as the authenticated law or verified law. State is the valid authority when it is concerned with the governance of nation. And whenever we talk about the laws of state, their main aim is to ensure peace and tranquility in nation. And then they are not driven by any ill motive, and therefore they are considered as the more trustable laws of the state. In case of dictatorship nations, they may not be in favor of people. We do find in some countries. But when there is a democratic setup, they are mostly drawn towards public welfare, and that's why we call it as a welfare state. And in case of our country, India, Schedule 7 of the Constitution of India we need to refer to. It gives the three lists: union list, state list and concurrent list. This we all know. Union list is meant for the statutes which can be enacted by the central government, that is the parliament. State list is meant for those statutes which can be enacted by the states, that is the state legislative assemblies. And then concurrent list, both can be done from these subjects, state government as well as the central government. Let us see what is the will of the people. As we see, the law is meant for the people, law is meant for the welfare of the people, and law is meant for the protection of people. And laws, they are meant to fulfill the requisite demand of people of nation. and they are mainly dominant in democratic nation, because whatever people want, it is the government of the people, by the people, for the people. So that is the democratic nation. And voice of people is prime consideration. It is also the optimum concern of lawmaking authority. And we always see that they are always compel the state authorities, this voice of the people always compel the state authorities to formulate the laws in their favor. Whatever is suitable to them, whatever makes their life easy. So law should be in a position to make the life easy of the people. And those people, they often support those governments who are ready to transform the people's will into the statute. Though only those governments will be popular, they will get re-elected, which governments will follow the people's will while they enact the laws. And the protection of women, the classic example we can see is this popularly known as the POSH Act, POSH, Protection of Women from Sexual Harassment Act, which was passed in 2013. This is just an example, because women at workplace, they were facing immense sexual exploitation and they showed angst through various platforms. And then the government recognized these people's concern and then they formulated this act. So this is the will of the people, we can see. Whenever any new impediments, problems fall before people and which need the urgent redressal, then the government, after doing the valid ratification, they can approve such a demand and they will enact the laws. They will convert those demands into law so that those demands will be fulfilled and people's life will become easy. So this is the will of the people, second source of law. Then we can see the material sources of law, and we will see now the customs. What are the customs which are being followed throughout the ages among the people? And customs can be of two types. One is the without sanction, another is with sanction. When we say the custom without sanction, obviously it is non-obligatory. And we can see, especially in case of the personal laws, like let's say Hindu laws or Mohammedan laws, we can see such things. So without sanction customs, they are non-obligatory. But if they are with sanction, they are obligatory. They are enforced by the state. We can consider the personal laws in this. And then in case of the customs which are without sanction, they are observed due to pressure of the public. Because the public demands them, then that's why they are being observed. The customs which are with sanction, they are the legal. They operate as a binding rule of law. And conventional customs are also there, which are govern the parties to an agreement. Okay, so this is important. And that is the reason why the customs without sanction, Austin considered those customs as the positive morality. This we need to know about the custom. When we consider custom and it is as a source of law, we need to consider this important thing. That is, what are the essentials of a valid custom as a source of law? And Blackstone, the great jurist, he mentioned the 6 essentials of a valid custom. Number 1 is antiquity. Number 2 is reasonableness. Number 3 is continuous observance. Number 4 is certainty. Number 5 is consistency. And number 6, that it should be conformity with statute law. Now let us see what it means. When we say antiquity, it must be proved to be in existence from the immemorial, from any time before say 1189 as per the English rule. But in case of Indian rule, there is no such time is given. Any year is not mentioned in case of India, but yes, for English rule, they mentioned the year 1189. Now, when we consider as the reasonableness, it is the toughest test for a custom to consider this as certain standards which are established for the courts to proceed, and the general observation of a custom, then the presumption is that it has a rational basis. It is useful and convenient, and reasonableness of the custom will not lead to become of law. But if it is unreasonable, then it will definitely abstain it from becoming a law. So this is important, and the case law is also mentioned here. This is the Ramdhan Lal and others versus Radhesham case. In this case, this has been held. When we consider as the continuous observance, this must be practiced continuously. Any custom to be as a valid custom as a source of law, and it should be without any changes from time immemorial. And the case we can refer is this Bahanarayan versus Sabasa. Then we consider as a certainty, it should not be vague or indefinite. It should be certain custom followed in the communities. And then the consistency. Any custom must not come into conflict with the other established customs. And consistency among the customs is also important. We cannot have the different customs in so that they can become the valid custom of law, valid source of law. So custom has to be valid, and ultimately it should be conformity with the statute law, because you cannot go beyond the statute. It will be ultra vires. So this is important as a custom, as a source of law. Then after the custom, the next legal source of law will be the case law or the precedents. And here we can see the precedents is simply means judicial decisions of courts, all courts, Supreme Courts, then High Courts. But in case of India, Article 141 of the Constitution of India talks about the presidential binding on the lower courts. Whatever decisions are given by Supreme Court, they are binding on the lower courts, High Courts and other courts. But Supreme Court's own decision, they are not binding on them. They can be flexible and they can change. We consider judiciary as the one of the strongest pillars on whom we can depend upon to seek the laws. So judiciary is the strongest pillar in such case. Judicial decisions, they are also considered as precedents, are those judgments of courts which have taken the shape of laws over a period of time, unless and until any concrete evidence or facts are presented against such precedents set up by courts. The decision will be treated as an established law forever. Whatever decision given by the court in case of the previous legislation, previous litigations, they will be considered as the established law. And the ratio decedent is most important while we consider the precedent. Ratio decedent simply means it is the reason for a decision. Why such decision is given? What is the rationale or what is the reason behind them? It is the laid down by judiciary and behind its judgment, and it answers all the customs, all the concerns which arise, and making the law more authentic. So judiciary assists the state also to formulate the laws which turn out to be more definite and reliable. So this is the importance of the precedents or judicial decisions of courts. Now we will consider the next source of law, that is the legislation. And legislation, as we know, the word has become from the two again Latin words. One means legis, another is latum. Legis means law, latum means making. So legislation means process of lawmaking, and we know the legislature is entrusted with this power of enacting the laws. And declaration of legal rules by competent authority. This is the legislation. And in case of modern times, this is the most potent source of law. Whatever legislature finds important, finds rational for the welfare of the people, they can enact the laws. And these are the rules by legislature which the state recognizes as law. And it has the force and authority of the state. Most important, the state has got the authority, its state's authority and state's force also. It is the exclusive source of law with advancing citations and power of supreme legislation, of whom Parliament of India, strictly defined in the Constitution of India. So in case of, even in spite of having the state list and concurrent list, the union list is important. The Parliament of India has got the upper hand, while in case of any discrepancy comes in case of legislation. This is the supreme legislation. We need to remember. Austin has mentioned this very important thing. He says legislation includes the activities which result into lawmaking or modifying the provisions in the existing law. And law without the legislative act is not there, and power of legislation rests in the sovereign authority of a political community. This is said by Austin. So again we will re-summarize this. These are the sources of law, formal and material. In case of formal, we have seen the will of the state as well as will of the people. In case of material, we have seen the legal and historical. And for legal, we have seen the customary law or customs, then case law or precedents, and lastly, the legislation or the statute law. We have also seen what are the essentials of valid custom. So these were the sources of jurisprudence. Thank you. Thank you very much.